some of the biggest myths and misunderstandings about estate planning. And I think one of the biggest is that people think of estate planning as a will. What happens when I die? Because we all know that at the point we die, whatever we have is going to be passed down, we hope, to those who we hope to receive it. So people are thinking about, well, I need a will. And I think that's one of the biggest misunderstandings about an estate plan, because in my opinion, as an estate planning and elder law attorney, and based on the thousands of clients and years of experience in this area of practice, the most important thing you can do for yourself is protect yourself while you are alive through the right estate planning documents. So I do personally think that that's the most overlooked piece of an estate plan. And we are going to spend some time today talking about how do I protect myself while I'm alive through not just having an insurance policy, which of course I highly recommend, but through an estate plan. So what is the one document? And if you've heard me talk about this before, you know where I'm going with this. It's no secret. The biggest, most important document you can have during your lifetime is your durable power of attorney. Why do I say that? And you should have one, and it better be a good power of attorney, because if you have one and it's not a good one, then there's going to be some problems. So let me give you a little bit of context about why I think one of the biggest secrets is that your most important estate planning document is your durable power of attorney. As an elder law attorney, I have worked with many clients and seen how devastating certain illnesses are, especially as people age. And I'm sure you can relate to that if you have helped a family member, parents, maybe spouse. It is not inevitable, but commonly what we see as people age, a decline often in their cognitive capacity. It could be a disease process, Alzheimer's, for example, Parkinson's disease, or it could be something that it happens, very quickly. For example, a stroke, which might create the inability for somebody to take care of themselves. So we see this often as estate planning and elder law attorneys. And one of the things that I do want to share with you, oftentimes people who won't have put into place estate planning documents are those who are fiercely independent, strong-willed, capable. They consider themselves to be completely in charge of their life. And frankly, they don't want to think, and they don't allow themselves to think about a time when they have to be dependent on somebody else, when they have to trust somebody else to manage their affairs, because it's anathema to them. They don't want to see themselves as not being fully in control, and that's natural. I think that's human nature. But I have to share with you that in my role as an estate planning and elder law attorney, it is very common to see people who were brilliant and capable and independent have something happen to them and they no longer are. And if they had the foresight or the fortitude, I will say, to get their estate plan in place, to get a good, durable power of attorney in place, they are so much better off than somebody who just put their head in the sand and said, hey, it's never going to happen to me. I'm not going to do any documents. Let me tell you why. Because if that person didn't plan for a day when they might be incapacitated, and it does happen to them, they, for some reason, lose the ability to manage their own affairs, and they have not put into place a durable power of attorney. The legal system requires that somebody have the legal authority to manage that person's affairs. Who's that going to be? That is going to be a court-appointed guardian or conservator, and that is through a court process. When I say court process, and I'm talking about who's managing your affairs during your lifetime, and if it's a court process, what that means is that everything about your life is recorded in the court file. There's been somebody appointed as your guardian or conservator. It could be a family member, or it could be somebody you've never met before. It's costly, it's intrusive, it's public, it's complex, it's frustrating, especially for family members that might not be your guardian and some other person is managing your affairs. It is frankly one of the worst situations you could ever put yourself into, because not only have you lost your voice, your ability to speak for yourself, manage your own affairs, but you haven't appointed anybody that you trust to do so. So the state, through the court system, has come in and they have control over what goes on in your life. It doesn't take much of an imagination for everybody to say, I don't want that. That sounds horrible. And frankly, it is. So when you hear of terrible outcomes and estate planning and other things gone wrong, it's usually because there is not a good estate plan in place. And frankly, what I mean by that is a good, durable power of attorney. It is the most important document you can have, your durable power of attorney, bar none.